Well, Ian, thank you very much. I'm convinced.
Only you had a vote, right?
I used to, but folks, now's the opportunity for you to, as we suggested right at the outset, to ask some questions of Professor Harper on the issues that he's outlined in a very detailed and very thorough way, or on some of the specifics that I'm sure many of you in this room have delved into since the release of the report by the government at the end of March. There will be some roving microphones coming around from my colleagues here. If you do have a question, please, the usual procedure, raise your hands if you could indicate who you represent or from whence you came, and then ask a question as opposed to perhaps a dialogue debate. I've got one at the back here, and then I've got one over here to my left.
Nassim Kadem from Fairfax Media. Ian, your report identified these new emerging sharing economy kind of services like Uber and Airbnb, and basically said that the laws need to be changed to allow these services to come in and not protect incumbents. So if we are not protecting incumbents, if we're changing the laws, do you see a scope for compensating taxi drivers who've spent $500,000 on getting taxi licences?
The report is quite clear about the need to consider transitional arrangements, and it's not our place to indicate what those transitional arrangements would specifically be, but there is no doubt that if people have invested in good faith in assets, then for the government to come along and suddenly reduce the value of those assets to zero would strike many Australians as unfair, even if in the longer term, in the medium term, we prefer to see things changed. So we speak to the question of transitional arrangements in the case of taxis, in the case of pharmacies, and you won't find that the report or the panellists are offside on that issue at all, I don't think. Phil.
Thank you, Chairman. Phil Riven, Chairman of Ibis World. Congratulations, Ian, on a stunning report and a nice speech. Two things, I think, to do with productivity, which you did raise, and we do need to address that, seem to me to be, first of all, the labour market. It's almost 50% of our GDP. The second, of course, is fast broadband. Now, it concerns me that I think our IR regulations are probably more suitable to the industrial age than they are to the post-industrial age. Second point is that we're not even in the top 30, I think, now when fast broadband is mentioned, and I find that very tragic. And I think both of those have got a lot to do with both competition and productivity. Were you, in your terms of reference, allowed to address those particular issues? And if so, how did you handle them?
Thanks, Phil. On the labour market, you'll be aware that the government has subsequently given a reference to the Productivity Commission to consider Australia's labour market regulations. They weren't part of our terms of reference. They were a part, or they are a part now of what the Productivity Commission's been asked to do, and so we didn't go there. Apart from those areas, and there are basically two of them, secondary boycott behaviour and trading restrictions in industrial agreements, where the competition law rubs up against the labour law. In those two areas, we have some discussion, as you'd be aware, but more broadly not. Phil, as you understand, while competition policy is an input to productivity growth, there's a whole lot more to productivity growth than just competition policy. One of them, indeed, is labour market regulation. That's not on our agenda. It wasn't part of competition policy, apart from the areas I've just indicated. And in the area of fast broadband, again, this wasn't a telecommunications inquiry. What we did do was to recommend that the access and pricing regulator take over the regulation of telecommunications more broadly, including broadband, presumably, and at least in that regard, coordinate the access and pricing issues that may be standing in the way of faster investment in that area. That's the two respects in which I'd see we covered those issues. Thank you.
While people are thinking, inevitably, Ian, when you talk about choice and you talk about competition, there will be an opportunity for a sector of the Australian economy, small business, for example, where there will always be negative stories that can be developed. I turn your attention to, I think it's the Fin Review today, talking about what people could construe as market dominance from the big hardware providers and the subsequent closure of the family-run small businesses that were involved in that, often as subleasees or as holding a part of a former company that was subsequently swallowed up. How, from your review's perspective, do you respond to those sort of comments that dominance by a restricted number of major entities in an economy which has 23 million people, 24 million people only anyway, is going to adversely affect the opportunity for those myriad of small businesses that people constantly remind us are the lifeblood of the Australian economy?
Yeah, thanks, Stephen. Let me tackle this firstly by just relating some stories. I sat across the table, as you might imagine, during the last year, as did Sue and Peter and Michael, from a lot of people who were running small businesses, in some cases owned 2 or 3 of them, small supermarkets, and who had stories to tell. And these stories had to do with the amount of money that they'd invested in their businesses. They were telling us stories about the up-to-date nature of the refrigeration they had or the different issues, giving us clear impressions that these are businesses which, make a contribution. And one had no doubt about that. So what was the issue? Well, the issue is, of course, one of the largest supermarkets has opened up a shopping centre up the road, and they've taken 2/3 of my customers. And the conversation would then go one of 2 ways. I'd say to the person, well, I'm obviously sorry to hear that from your perspective, but these people have not been forced up there at the point of a gun. That they've gone of their own volition. Is there nothing that you can do when you're talking to your own customers to induce them to come back? And people would generally concede that that was not the case. Well, how can we possibly compete? We can't meet the prices that our customers want. We can't offer the variety. And I say, well, yes, but you can't blame the large business if it has opportunities to do that from offering what it turns out as a superior offer to your customers. Are you asking this panel to change the law to prevent that? Most people, even though they've got a lot at stake and, of course, don't like what's happening any more than I did, I grew up in a household where my father was a butcher, and I know all about the long faces that would come home whenever a large supermarket would open up within the vicinity of my father's shop. I know about all this. And it isn't very pleasant, but it is part of the competitive process. People have an innate understanding that's the case. You pretty quickly end up in a discussion which says, well, we understand that having market power is not illegal. It's not. Being large enough that you have market power is not against the law, and it shouldn't be against the law. What is against the law is misusing market power. And in Section 46, as it's presently drafted, it says what's against the law is to misuse your market power, which means to take advantage of the market power that you have for the purpose of damaging a competitor. Now, in our view, that particular section of the Act, given that it's the only one that speaks about damaging competitors, it's the only part of the Act that speaks about that, is out of step in an era when the types of choices that people want, what technology is making available, and given our circumstances in a globalising world, will inevitably mean that business in many cases is going to get bigger and bigger. The fact that in that process small businesses get hurt ought not to be in and of itself a problem. If the competitive process is compromised, that's a different issue. And that, of course, is precisely how the Act is worded in the other cases, where it says quite clearly, for the purpose, with a purpose, effect, or likely effect of substantially lessening competition in a market. That's the test in Section 45, the test in Section 47, the test in Section 50 is exactly that test. And the courts have a lot of experience in dealing with what that test means, whereas the courts have often found it difficult to interpret what take advantage for the purpose of harming a competitor means. So our recommendation was to align Section 46 with the rest of the Act and to move the focus away from the impact on competitors to the impact on the competitive process. So the invitation to the small businesses who have this concern, Stephen, is firstly to say having market power is not an offence. But using market power in a way, if the government were to take our recommendation, which had the purpose, effect, or likely effect of substantially lessening competition in a market, that would be an offence. And any concerns about certainty, well, it's not as if the existing law is certain. People don't know how the existing law works. That's the point. The jurisprudence is very unclear. So to say to me, oh, you people would introduce a whole lot of uncertainty into that misses the point. The existing law is uncertain because of the way that it's phrased. So our view is that the proposal we've put would certainly help us to deal with these sorts of issues and focus the attention where it needs to be focused, and that is on the competitive process, Stephen, rather than the impact on individual competitors.
I have another question. Nobody else seems to. That's fine. Human services. And I'm particularly taken by your example of using higher education as one. In the light of government attempts to date to try and bring about some changes in the higher education sector, which in itself may be interpreted as providing a choice mechanism as well, that you're obviously quite wedded to. How does your report tie in with some of those proposed changes that the government sought to implement but is having difficulty getting through the Senate?
Well, Stephen, those who've read the final report will be aware that we don't go into specific details in any of these areas. Our job was to establish principles which we thought were applicable across the economy. And the one new area that competition policy has not spoken about before is human services, health, education and welfare. And there what we do is to speak about the capacity for choice, contestability, diversity of providers to be introduced in those areas, including, as you say, in higher education. And both higher education and in health, Australians, again, are used to the fact that there are already private providers and public providers. I mean, there are private universities in this country. Of course, there are private schools. There are private hospitals. Primary medicine is essentially run by hundreds of individual small business people, doctors. There are big public hospitals and big public universities. So it's no news to Australians that there could be the potential for competition across that boundary. These recommendations are addressed specifically to the public sector. We're saying, yes, but you don't have to stop there. The public sector doesn't have to be the margin where competitive process, where choice, flexibility and diversity stop. That the public sector is known for you can have any colour you like so long as it's black. That doesn't have to be true. You can split up funding, regulation and provision of public services in a way which can encourage the equivalent of contestability and competition, even while public ownership remains true. So, Stephen, I don't want to go into the detail of particular areas because the report doesn't do that. But what we hope we have done is to provide the government, well, the people, with an overarching framework within which you could think about ways in which the public provision of these services could be more easily contested, with the end result of giving people greater choice, while of course preserving access and equity.
Professor Alan Fells.
By the way, just on taxis, the cost of compensation in Victoria is 1.8 billion. I want to congratulate you on the report and
Thanks,
including the proposals to change Section 46 and to bring it into line with the 129 countries around the world that decided this question long ago. There are no exceptions, there's only New Zealand. Now, on your comments on the market for human services, I think that's another good part of the report, and you've half answered the question I was going to answer just a minute ago,
Yeah.
but I wonder, what are the lessons, if any, that you see from this government's troubles with bringing in not dissimilar type reforms into higher education with deregulation, the co-payment saga? They all indicate that maybe most reforms in human services of the type you talk about are really complicated and difficult, but probably worthwhile. So do you have any conclusions from those experiences?
Thanks, Alan. A lot of the discussion, certainly about the co-payment, and to some extent the discussion about the university reforms, turn on funding. a lot of this is motivated by concerns of a budgetary nature. I'm not going to suggest that those concerns aren't valid, but this report doesn't speak to funding or budgetary questions at all. This is about how to drive choice and diversity and flexibility. And in the area of human services, for instance, health in particular, we make it quite clear we're not talking about reducing or increasing, for that matter, the funds that are available for this. This is about how you can generate improved productivity from both sides. Oftentimes people think when you use the word, or an economist uses the word productivity, you're just talking about cost. That's not true. Productivity is a ratio of value of output to cost of input. And if you can drive the system such that it produces greater value for people, even if it costs more, you may well have improved its productivity. So we don't get into that discussion so much as to say that if you can drive these systems to provide much greater choice and contestability, the likelihood is you'll do both of those things. You will improve the value that people get from the system, and you will improve its cost of production, most likely. That's where we're coming from. And we don't think that that principle is really, different for education, be it tertiary, primary or secondary, health or disability, or any of those areas. I've used the example before, you may have heard me, forgive me if you have, but it's such I think, a telling example of the reforms in the disability services area, of just the simple human value that was reported to us by a disabled Australian who was now able to order a meal to his taste rather than accepting what it was that was delivered, that he could make that decision. And another disabled Australian who was able to decide to use the allowance which he now enjoyed to order different types of services for his personal care than had been allocated before. These are the sorts of things, ladies and gentlemen, and I apologise for being overly emotive about it, but I think it's a very telling example that everyone in this room, unless you're related to or you know very intimately somebody who does suffer from a disability, we take for granted these simple elements of human dignity. But for someone to be able to say, what I now have is the freedom to decide the type of care that I want in a very intimate context, or the type of food that I want to eat, those things can provide for the lives of those Australians enormous improvements in value, even if they do cost more. Well, why shouldn't the same logic apply right across the human services spectrum? Can I also point out that it's not as if this is some flash of brilliance that has come to the fore of us. These ideas are not new. Indeed, many of them are being tried as we speak, not because we said so. States and territories have already started down this track, and certainly other governments around the world, most notably the United Kingdom, have been working on these sorts of ideas for years. Our report is simply saying, go there, do that. Yes, it is complex, as Alan says. Spend the time and the money and the effort to work out how to do this. And it's true, as the Tasmanians reminded us, this type of logic can't work in every corner of the Commonwealth. Fine. If it can't work there, then don't let it work there, but understand why. Because it may well work elsewhere in the country and the benefits are really strong. And on one final little piece on Section 46 I should have mentioned before, people have also pointed out, as we do quite openly in the final report, that previous reviews of the Competition and Consumer Act have, apart from two predecessors of our own, rejected the type of change to Section 46, the so-called effects test, that we have recommended. Can I urge the audience to be very cautious with that? The other inquiries rejected introducing the word effect or likely effect into the existing wording of Section 46. Let's be very clear. My colleagues and I would not just introduce the word effect if the aim of Section 46 was still to pick up people who damaged competitors as a result of conduct in a market. That would be inappropriate, and that, I believe, is why the other inquiries reached the same conclusion. We have changed the whole focus of Section 46. That's why it's inappropriate simply to throw around the words effects test. If you want to throw around the words effects test, then make sure you apply them also to 45, 47 and 50 and ask yourself why there isn't a problem there. There isn't a problem there because the focus has changed from damage to a competitor to damage to the competitive process, and that's precisely what we recommend for Section 46.
Thanks, Stephen, and thanks, Ian, as stimulating as always. In your interaction with international players, which I think you said you did via conference, did you find one or two players whom you regarded as truly excellent relative to us in what they had achieved? If so, which were they and what had they done?
Peter, you'd be the first to say, given your international career, that solutions which work remarkably well in other parts of the world can't necessarily be transplanted and expect them then to flourish in local soil. You understand that. So what we learned, particularly from, we had experts obviously from the United States and from Britain in particular, but people who could speak with authority about the Canadian experience and some experiences elsewhere on the continent, is that the way these rules work in different contexts depends very much on the context. But what we did take from those experiences were, for example, well, let me give you a specific instance. We rejected any notion, and people did push us in this direction, at least some people did, that there would be divestiture brought in as a remedy or penalty into the CCA, based on the fact that that's available in the United States. When we went to speak to the United States, or in particular to the reps there who could speak about this with authority, they said, well, yes, of course it's there, but you need to understand that is extremely rarely used. Right? And when it is used, it produces a major upheaval. So you learn things when you ask people face to face, even those just across the Tasman. We were told all sorts of stories about Fonterra and the so-called National Champions Test, only to discover when you actually sit down and talk to the Kiwis face to face, the facts of what they did in the Fonterra instance are completely different from what you might read in a national daily newspaper. So, Peter, the key benefit of talking to foreigners about their experience, and of course they're all very, very cautious about telling us how to run our shop. You ask them about their circumstances. How does this work where you are? We'll make up our minds whether it works here. And I say, oh, well, in that case, let's tell you. We don't do this, we don't do that. No, we didn't do this, we did this and this. And those sorts of things were very effective indeed. The basis for our original recommendation about putting a board in charge of the ACCC was informed very carefully by experience in Britain, where that's true. In the end, as a result of submissions coming back to the draft report and other representations made to us, we walked away from that, because we didn't think in the final analysis that it would be grafted into our circumstances. And we learned that lesson.
I think that's probably an appropriate note to draw this conversation to a close. And in proposing the vote of thanks to Ian, could I again simply say, not only is he a dynamic presenter, but someone of clarity of thought and someone who is able to very much demonstrate the way in which a report that he has had carriage of, along with his colleagues such as Sue McCluskey that's with us today, can express what those recommendations were. I think the way he's been forthright as always in responding to questions is very much a testimony to the man himself. I said a little earlier that he's been involved with CEDA for a very, very long time, and only 37 years, and well, that's good. We've only been going 55, so you've been right there from the inception. And we anticipate that Ian will continue to play a very strong role with us. Could I then invite you all to thank Ian so much for his presentation.